2004 decision, which is, my lord, reiterated and approved by another 3-judge bench judgment by Justice Chandrachud as Lordship then was. And, my lord, each paragraph dealing with each judgment gives the duration. And, my lord, therefore, the court said that the concept of the appointment being void will be applied. And therefore, what duration you have spent is immaterial. Now, my lord, there was a doubt again. And then, my lord, it went to another bench on 4 years, where, my lord, your lordship will get that judgment by Justice Parthivala, my lord, 322. This is Satish Chandra Yadav. Entire law is discussed again. And I just wish to, my lord, your lordships, I wish to show the last paragraph where, my lord, this argument of 4 years, etc. have been put in. So kindly come to 106. My lord, the judgment repeats, my lord, up to the law laid down in FCI, analyzes FCI of 2017, and, my lord, on the facts of that case, kindly come to para 106. So far as the connected appeal arising of so and so, filed by so and so is concerned, the same also fails on the same very line of reasoning adopted by us. The only difference in case of appellant is that he had put in 4 years of service before he came to be terminated. So time spent is immaterial. The concept of appointment having been obtained illegally and void appointment, therefore that will not be a factor to be kept in mind by the court that they have spent time. Now, my lord, therefore, if for the appointment has to go, number 1. Number 2, no hearing is required to be given. Number 3, time duration is not to be seen. Kindly, my lord, now come to this small compilation which I have handed over. 3 authorities were before the High Court. Now, my lord, this test. Respect, my lord. Now, my lord, in 136, your lordship considering, my lord, the judgment of the High Court, whether the High Court has wrongly applied any principle laid down, my lord, I just wish to take 10 seconds of your lordship, my lord. The first criteria is, are there any gross illegalities? If there are gross illegalities, then generally, my lord, generally, the entire process must go. And that is, my lord, by server principle, my lord, which was in the case of, my lord, admissions.
Limitation.
Which is on admissions, my lord, in the MBBS courses, the court now adopted a principle that even if there is a possibility of not identifying even one person who has illegally gotten admission, but they could not get detected, the process must go. My lord, I had the occasion to save that process. My lord, I was appearing for the government and CBI, and my lord, these were admissions to the, my lord, the counseling which was to take place for MBBS admission, and the effort was why everybody should suffer. So the court said, even if you are not sure about one, the process must go. Then, my lord, that as I had already said, my lord Chakradhar, no individual hearing is necessary, and FCI we say no period. No period should impact the court. Now, the next submission which I am making is, my lord, is there any default or a defect in the learned High Court not following your lordship dictate? The principles not followed. If principles are not followed, the general rule is no interference under 136. And now kindly see what the High Court does. High Court asked the three authorities first. Can you assure me that this list is final? Kindly come to para 242. Now I am only giving the responses which were specifically asked from these authorities. They got recorded in the High Court judgment. Please see the approach adopted by the High Court. In my humble submission, it is absolutely the approach which need to have been adopted in compliance with the principles your lordship have laid down. 242. If your lordship may have my note, my lord, I have given the relevant line. I can go to the judgment, but it would save time. The first authority who's asked is SEC. Are you sure about the number of the people who have illegally obtained it? In course of para 243, the relevant line, in course of hearing, SEC did not discount the fact that possibilities of further illegalities are there. Then kindly come to 272. Before I read 273, kindly come to the next page, para 265. I'll come back to 273 later. Kindly come to 265. This was SEC. Now please see what is the stand of the state. Para 265. State government therefore has accepted there were widespread illegalities in the selection process and that the number of persons who received appointment illegally could not be determined with exactitude. So the SEC raised hands, state raised his hand. Kindly come to the previous page 273. Last line on the page number 2, my lord. SEC at no stage of hearing claimed that it was able to check all the records and be definite as to the number of illegality in recommendation made, but had limited itself to those figures as stated in the paragraphs above. In fact, reports in the form of evidence filed by SEC from time to time had always stated that they discovered the illegalities were brought to their notice by the litigants or by the orders of the court. And if it is left to them, they raise their hand in despair. We cannot find out. Now please see, my lord, the state says I can't find out. No number exactitude I can give. And my lord, the finding is recorded in para 269. SEC board and the state government have consistently stonewalled any query with regard to selection process and have not come clean with regard to the manipulation, illegalities involved. Conduct of three authorities during the course of hearing can be classified as anything other than being cooperative. These findings are not, my lord, there is no quarrel with these findings. This actually happened. Therefore, my lord, the High Court said, first of all, I must find out from these three authorities who are directly involved, everybody running away. They can't even be sure what is the number. They say we have not even been able to collect our record. We have not been able to verify our record. We cannot tell you. Then, my lord, kindly see what the High Court does. The next, my lord, from 320 onwards.
Yes, Father.
Now, these are the principle, the observation made by the Honorable High Court with regard to three authorities, non-cooperative and admitting that we have no record, whatever record we have been able to see, we can't say with certainty how many people have illegally obtained it, nobody can say it. High Court now, my lord, with this admitted factual position, applies your lordship principles, my lord, which have been laid down. Kindly come to para 320. These paras, my lord, I am relying upon. Your lordship has read many times. Only three I will read it. I have given it in the written note, my lord. Your lordship may kindly consider. First is 320. In the event it is impossible or highly improbable to shift the grain from the shaft. So please compare it with para 20 of Tanvi server. Even if one has illegally obtained, even if he remains undetected and that probability is there, quash the entire process. Kindly come to 326. The entire selection process is shrouded in such mystery and in such layers that it is difficult to fathom the quantum of illegality performed. And, my lord, I am beseeching your lordship's indulgence. Please test these, my lord, observations in the light of the jurisdiction under Article 136. Is there any such a defect committed by the court, my lord, by the High Court, which, my lord, shakes the conscience of this court to interfere in the matter? Kindly see 329. Now, my lord, I had the occasion to appear in Assam case, my lord, where the OMR sheets, they disappeared, and, my lord, in the house of the chairman, blank OMR sheets were found, so that whosoever comes with money, he is again, my lord, blackened and pushed in. That is, and all appointments are quashed. Kindly see, my lord, 329. Blank OMR sheets have been submitted. Such candidates have been shown to record sufficiently high number. The exact nature of candidate fraudulently given the appointment cannot be identified, more so in view of the attitude of non-cooperation exhibited by SSE. There are other manipulation illegality in the selection process which have not come to light. And 330, since it is impossible to separate the grain, therefore we have no other option. Then 331, retaining appointees selected through such a dubious process would be contrary to public interest. 332, the selection process does not inspire confidence to hold that appointed person had been selected in a fair and transparent manner. Person submitting blank OMR, she had secured appointment, amongst other illegality, and therefore, my lord, those directions are quoted in the note, in this note on the subsequent pages, and in para 9 onwards, my lord, the judgment compilation which I have handed over with those 4 paragraphs to be kept in, my lord, consideration by your lordship. Therefore, my lord, it is a case where the conclusion drawn by the Honorable High Court, in my humble and respectful submission, my lord, do not fall foul of any of the principles which have been laid down by this Honorable Court, which ought to have been applied, have either been not applied or wrongly applied. Therefore, my lord, your lordship under 136 will not, my lord, consider this case, but for only, my lord, quashing the entire selection process and, my lord, the recruitment and selection to be made once again, my lord, so that no merit is compromised. And this colossal fraud which has taken place, my lord, is suitably dealt with by your lordship, my lord, by confirming the judgment of the Honorable High Court. That's my respectful submission, my lord. I am deeply obliged. My lord, great.
Your lordship, sir, I'm appearing for the candidate.
CBI.
Come.
What do you have to say?
Lordship, in this regard, the first query that was put to us regarding the authenticity of the data that we had recovered from Pankaj Bans. Regarding that, on the last occasion, Mr. S.V. Raju had handed over a note, a 3-page note. If required, I have fresh copies again. I can.
Just give it.
Can we have copies, please? Can we have some copies?
My lords, may we also have copies of the note?
Copy.
Yes.
Can we have some more? Can we have some more copies, please?
Lordship, it comes to the first page. Lordship will note originally the entire scanning process. The entire scanning process was originally done by NISA. NISA had given it to another authority, which was Data Scantech. Data Scantech was the authorized authority. Thereafter, those data was provided to the SSC. SSC had deleted those data as per their rules. The examination period was 2016. Evaluation was done in 17. This pertains to 4 stages of examination: Group C, Group D, 11, 12, 9 and 9, 10. Now let's see, when we asked NISA that please provide us the data, NISA said we do not have a copy of the data. Thereafter, we went to Data Scantech. From Data Scantech, we had recovered data from the deleted portions of the files. So we had this one set of data which we recovered from Data Scantech. The files were originally deleted, but we managed to recover those data. Another set we recovered from the 3 hard disks that we recovered from Pankaj Bansal. So we had 2 data to compare with. Now let's see, whenever the scanning was done, it resulted in 2 versions of the copies. If Lordship comes to the first page, there is an image copy, which is an exact scanned copy, and another is a response code. If Lordship also sees, in the impugned order also, a response code sample has been put in at page 238. If Lordship sees both side by side, the picture may be a bit clearer. Page 238 of the impugned order refers to a report of the CBI which was submitted before the Honorable High Court. In that report, we have also given details of the investigation, how the data was recovered and everything else.
Page 238.
238 of the impugned order. In the bottom, Lordship, you will see there is a table put in.
Yes.
This table is the data which is equivalent to the response code. So we had to match 2 forms of data. One was the image copy, one was the response code that we had recovered. Now let's see, we checked with the response code data with that of the data which we got from the panel evaluation. Also, we'll come to the reasons portion, which is on the next page, and I will go through.
No, I just couldn't understand.
Yes, Lord.
There was a scanning done.
Yes.
Now, sometimes the scanners themselves mark the papers,
Yes.
depending upon the circles which have been plugged.
Yes.
In this case, that is not done.
Yes.
It is manually checked.
Yes. No, in computer generated checks. So that's why we got the
It's a
response.
computer generated
Yes.
AI check.
AI check.
So it was automatically, you feed in the
Yes.
OMR sheet, you
Yes.
get the answer.
Yes.
You'll get the marks.
Yes, Lord.
It was not done manually.
Not done manually.
But there is discrepancy between the OMR data found on the hard disk or retrieved from the hard disk from DataScan
Yes.
and the 3 hard disks which were retrieved or which were seized from Pankaj Bansal.
Those matches, Lordship.
They match.
Yes. That's why I come to if Lordship comes to the second page of my note, I will read that first. It will be easier.
So what do you mean by this?
If we
Response code, what do you mean by response code?
response code is that table format which I was trying to show at page 238. That is the response code data. And another is an exact image copy once we scan an
Okay, fine.
image copy.
Okay, fine.
So we get these 2 at the time of scanning, 2 copies, image copy and response copy. Now this response code is used to validate the answers provided by the candidate
Correct.
and calculate the marks based on the predefined answer keys corresponding to each question paper. This is done automatically. And authenticity, for authenticity check, then there is a stage where the scanned OMR sheets can also be checked so as to ensure whether the automated checks that was done through the machines matches with that of the scanned data or not. Then verification of the hard disk, and then I will come to the reasoning, Lordship. Why we say that the data which we got from Pankaj Bansal is actually genuine and authentic. The first is, as directed by the Honorable Single Bench of the High Court at Calcutta.
Yes.
I'm at the second page of my note, Lordship. The reasons, point number 1.
Yes.
As directed by the Honorable Single Bench of the High Court at Calcutta, the scanned OMR images retrieved from the seized hard disk belonging to Pankaj Bansal were handed over to the West Bengal Central School Service Commission. The WBCSCC subsequently evaluated these scanned OMR images using the answer keys available with them. They had the answer keys. Upon evaluation, the marks calculated by WBCSSC matched the marks stored in the seized hard disk of Pankaj Bansal. This is the first point, that it matches. Second, during investigation, one email dated 15/7/2017 was seized by CBI, which was sent by Pankaj Bansal to accuse Subhiresh Bhattacharya, then chairman of WBC SSC, and via this email, the actual marks scored by the candidates in the written examination for the post of Group C was shared. The same data was also found in the seized hard disk of Pankaj Bansal. Then, as directed by the Honorable Division Bench of the High Court at Calcutta, an inspection of the scanned OMR images was arranged for candidates or parties who applied for such inspection in accordance with the court's order. Following the inspection, no candidate disputed the authenticity of the OMR image shown to them, asserting that it was not their own. These observation was also noted in the judgment, impugned judgment at paragraph 289. Then let's see the hash values. These are very important. The hash values of the data seized from Messrs. Data Scantech Solutions responsible for scanning the OMR answer sheets of WBC SSC candidates on behalf of Mrs. Naisa matched with the corresponding data found in the seized hard disk of Pankaj Bansal. So we had two data, the hash values match. Similarly, the response codes generated during the scanning of the original OMR answer sheets by Mrs. Data Scantech Solutions acting on behalf of NISA were found to match the corresponding data stored in the hard disk seized from Pankaj Bansal. This relates to the modification date. Whenever a file is created, it will create a modification date. So the modification date of both of these data, the one from the Pankaj Bansal and Data Scantech matches. Furthermore, the dates of modification for the scanned OMR images found in the hard disk sheets from Mrs. Data Scantech Solution and Pankaj Bansal were identical. These modification dates also correspond to the period when the written recruitment examinations were conducted by WBC SSC, thereby affirming the authenticity of the data. The differing dates of creation reflect the transfer of data onto a new medium, while the modification dates represent the actual creation dates of the original data. We also had the 65B certificate. We had produced those certificates before the Honorable High Court. Honorable High Court at this point has ruled in favor of the CBI.
Bansal data retrieved by you? The three hard disks?
Just a second. It was in September
2022. 16.
Yes, 16 September 2022. That's reflected at page 242.
And when is the scanning done? Date?
The scanning was done way back when the examination was conducted, evaluation was.
Comes in the picture for the first time in December 2023. In fact, January 24 in the charge sheet. And
Scanning, initial scanning.
not, that is a big question. Anyway, let him finish. That is a big question.
Initial scanning is in the process of evaluation only.
This
Now it's
paragraph-
hard disk.
Paragraph 6, what you've said.
Yes, Lord.
Please read paragraph 6 again.
Similarly, the response codes generated during the scanning of original OMR answer sheets by Data Scantech Solutions, acting on behalf of NISA, were found to match the corresponding data
Where
stored
did
in
you
the...
get this information? From what we understand,
Yes.
except from what was retracted from Pankaj Bansal,
Yes.
there is no other information available. The
Data Scantech
Service
had the
Commission
data-
doesn't have any
No,
hard
Data
copy.
Scantech had the data of the response codes data. So we compared first of
Mirror images are not available.
mirror images are not
So
available.
this
We recovered
response
all-
code is still available.
Yes, the response code data, one set we got from the Data Scantech, one set we got from the hard disk of Pankaj Bansal. We compared both and the relevant modification time matches and the date on which the original examination had taken place.
Mark sheets of
Yes.
Pankaj Bansal data, you have to show there were gaps.
Yes.
There were gaps and manipulation was done.
No, Pankaj Bansal data is the original data.
Original, that's the original data.
Yes, that's the original data.
According to you.
No
that-
tampering.
No, that has not been tampered with.
No tampering on that data. That is the original.
Hash values are as per the date on which the.
Original evaluation had taken place. in
So what's
17.
that?
Yes.
But the hash values should have undergone a change because a simple reason. And last year was the one who did that scanning.
Yes.
Yes.
Ni-
Yes. Yes.
Last year is the one who did that.
NISA actually gave.
But they gave it to them.
Yes.
But Pankaj Bans, therefore, but they had. The hash values, whenever there's second copying also will undergo change. So Pankaj Bansal is not the first copy. You also accept it's not the first copy.
No, I'm saying Pankaj Bansal is the second copy copied from the data that was available with NISA.
But when you copy.
It's the third copy, my lords. It's the third copy. It's NISA, Data Scantech, and then Pankaj Bansal.
No, NASA did not do it anymore. NASA didn't do it.
NISA didn't scan.
I beg your pardon, my lords. It's SSC, Data Scantech, and then Pankaj Bansal. And on the my lord, regardless, the last
Don't
case,
confuse us now.
just on the
Correct.
that's true. I beg your pardon, my lord.
Don't confuse us after so many hours.
That's true, my lord. My lords, just on the hash value, since the
No,
CBI
please, no.
it was the metadata of the hash value.
Join on this at my turn, but this goes to the root of the matter. This is crucial.
This is not evidence in the eye of law. They have to satisfy us.
Please.
This is crucial, my lords. This
We'll not hear anybody like this. We have heard you at length. We have already heard you, whether it's evidence in the eyes of law, whether Evidence Act applies, what is the effect of 65B. We've all heard you. Don't say that. Yes, please.
Now, Lordship, the first scanning that was actually done was done by the Data Scantech. That was the first authority. From Data Scantech, it has gone to NISA and then to SSC. NISA's one person was this Pankaj Bansal. Pankaj Bansal had copied the data, which we had recovered during a search proceeding. We don't have the now.
You have yourself about Pankaj Bansal also
Yes,
commented.
that the hash value matches.
No, but you have also said that there were gaps, because if you look at the Pankaj Bansal's, your argument before about Pankaj Bansal, which has been quoted just by Mr. Maninder Singh, you have said over there that it is not possible to it was not possible to rely even on that data.
The judgment of the division bench.
That's as per the division later.
Division bench has come to that finding.
It's not possible to rely upon even Pankaj Bansal's data.
But from our investigation, I can only say this thing.
That you feel that Pankaj
That is the original data. That is untampered.
That-
That is what our investigation has revealed.
And that data matches with the
Data Scantech data.
That's
Yes. And all of this matches with the same modification time.
But the marks which are appointments are not made in terms of that data?
No, not. That's why we say that there is a final tampering between the original data, which is the Pankaj Bansal data, and the marks and data which was subsequently put in and upon which all the appointments had happened.
So the data which is maintained by the SSC is tampered data.
Tampered data.
The original data, which is untampered data, is the data with Pankaj Bansal.
Yes.
Please. Chip, I'm appearing for the people who were excluded. They were they would have been in the merit list, but for the tampering, your lordships. So now, as per paragraph 335 of the impugned judgment, your lordships, various conclusions have been arrived at, and what was the irregularity and illegality, those have been secondly set in over here. If your lordships will just mark para 335, sub-para 8, small Roman 8, 9, 10, and 11, your lordships, 11 and 12.
335?
335, sub-para 8 to 12.
Yes.
So there are 4 kinds of major irregularities. The first, your lordships, is appointments higher than the declared vacancies have been given in respect of all 4 categories. Number 9, appointments have been given to persons who were not even in the panel. Number 10, appointments have been given to the persons who submitted blank OMR sheets. Number 11, appointments have been given to persons after expiry of panel. And number 12, persons placed lower in the rank have been given appointment in preference to persons placed higher in the rank. So your lordships will see that these 4 irregularities, in fact, at this time and distance, seem to be established. Because whatever SSC may say, it has come on record by way of investigation, by way of subsequent confirmation, by metadata, that the SSC data on basis merit list, on basis of which appointments were given, had these 4 categories included in that, which were illegally included. Then your lordships may kindly see, which is very important, is number 13, that the merit list containing the marks obtained by the respective candidates has never been published. For that purpose, your lordships, I had also indicated to your lordships the earlier order of the Honorable High Court when the entire scam had broken loose in the Honorable High Court. The Honorable High Court had ordered your lordships, wide order dated 12/5/2022, which your lordships will find at page 396 of volume 3 of the compilation. Page 396, volume 3. Lordships need not refer to it right now. Suffice it to say that a direction was given that the merit list should be published. However, that was never complied with. Then your lordships, what happened was that with regard to the rules, because when the High Court went through the rules which were to be followed, it found that the rules had not been followed. And for that purpose, your lordships, if I may just refer to the rules your lordships will find at page 93 of the compilation of volume 1. A lot will turn on the rules, your lordships. Lordships may see that I'm referring to class 11 and 12 rules, and their paramateria by and large of all the 4 categories. If your lordships will come to rule number 12, now the rule number 12, your lordships will see, provides the procedure for the purpose of selection. And going by the Nazir Ahmad principle, your lordships, 1945 Privy Council, which has been consistently followed, Rule 12 had to be followed for the purpose of declaration of the merit list and the procedure and the method of selection. Now, if your lordships will see, if I may just draw your lordships' attention to Rule 12, that the Central Commission shall arrange for proper custody of all online applications which may be received by it against the vacancies. Central Commission, after receiving application, shall prepare a list of eligible candidates for purpose of preparation of a computer-generated database of all the candidates. This is the preliminary stage, whether he is citizen of India, age bar, all those things. The admit cards for written examination shall be issued by Central Commission by any mode as may be determined by the Commission. Commission shall arrange written exam. Commission shall determine method of written exam, contents of papers, etc. Commission shall decide the procedure and the manner of conducting selection tests. Now the important part comes now, your lordships, which is sub-rule 6. After evaluation of OMR sheet or answer sheet of written examination, the Central Commission shall prepare and publish in their website with all details of the candidates to be called for personality test, category-wise on the basis of merit, marks of written test, academic and professional qualification, as mentioned in Part A of Schedule 2, in ratio of 1:1.4 of final vacancies. Sub-Rule 7. Central Commission shall prepare and publish in their website a merit list of candidates prepared category-wise on basis of marks obtained in, again, 3 aspects, your lordships. Then 8 is with regard to the proportion of 1:1:4. And then the proviso is important, your lordships, which is 1:1:4. And then subclause 10, Central Commission shall publish such panel and waiting list of candidates in the website of the Commission as well as offices of concerned regional commissions. Copy of the same will be submitted to School Education Department, etc. So the first merit list which had to come out, Your Lordships, was with regard to the eligible people for the written exam. After crossing the written exam, again another merit list was supposed to be published with regard to persons eligible for the interview test. After that, a merit list of 1.4 of the number of vacancies, 1.4 times of vacancies, panel had to be made, Your Lordships. And then Your Lordships will come to Schedule 2, which Your Lordships will find at page 99. And this is how the candidates were able to identify the illegalities committed. Your Lordships will see that there is a categorical breakup given of the exams and the marks to be taken and the weightage to be given, which could not be tampered with because the school exam, class 12 exam marks could not be tampered with. That was a fact, a hard fact, which SSC had no control over. So Your Lordships will see selection to the post of teachers of class 11 and 12 in schools shall be made on the basis of written examination, evaluation of qualifications of the candidates and personality test to be determined by the Commission in the following manner. So written examination is the OMR. The weightage was 55 marks. Academic qualification, including professional qualifications, weightage is 35 marks. And personality test is 10 marks. Now, Your Lordships may turn to Part B. And how, Your Lordships, the weightage of Clause B, which is the academic qualification, would not be a variable number. It would be a constant number, Your Lordships. Lordships will come to Part B. And if Your Lordships will see the first row itself, the examination is school final or Madhyamik or its equivalent, which is class 10. Full marks out of 35, Your Lordships, 6 will be given if you have got full marks in your class 10 examination. If you have got 60% and above, you will be getting 6 marks. There is no discretion in this. Below 60 up to 45, you will be given 5 marks, and below 45, you will be given 4 marks. And then there is relaxation in education for reserved candidates. Similarly, class 12 marks, the weightage is very clearly given. So, Your Lordships, now what has to be done in this situation where we find ourselves, Your Lordships, where these 4 irregularities have been committed, which have been more than established. And considering the fact that this is not a criminal case, because a criminal case is pending with the CBI, that as far as those consequences are concerned, those will come. This is a matter now, how are we to balance all the equities, including what do we do with the 2016 selection, where these irregularities have come to light only 2 years after the selection has taken place. It was consequent to 1 or 2 writ petitions which were filed, in which this entire thing came out, where RTIs were filed, where the whole fraud had come to light. Now, since the fraud was discovered only 2 years hence, Your Lordships, then the Lazarus doctrine will again apply, and what has to be done going forward has to be seen, Your Lordships. As far as making a merit list is concerned, now we have to segregate
You
tainted.
see, the difficulty is this.
Yes,
We don't have the original OMR sheets.
but CBI.
One
I'm
minute.
sorry, yes.
CBI says that the data with Panchal Bansal matches with the data which they've been able to retrieve from Canada, deleted data from Canada. But still we can't authenticate and vouch for.
Yes, Your Lordship.
We can't authenticate and vouch for that this is the original one, because in the absence of the original mark sheets, the suspicion is now today, even to the extent whether these are the original mark sheets of the candidates,
Very well.
whether these are original MOM data mark sheets of the candidates.
Very well.
Because if so much is happening, there's so much bungling which has been done, such a large
Yes.
scale, vast scale. It's impossible to authenticate that.
I'll just respond to that, Your Lordships. Now, let us see what are the alternatives that we are faced with. The first alternative is what the High Court has done. You can cancel the entire selection. Now, Your Lordships, 2016 selections, there were candidates.
And in this case, not only the problem is that,
Yes.
the problem is, one, we take the data as it is available in CSD, collate it,
Yes, Your Lordship.
match it with the
Yes, Your
Pankaj Bansal data. That would have been, if that was so simple, it would have been done. But today, date and age, when we have doubt on even Pankaj Bansal's data because the original OMR sheets are not there, then what to do?
Yes, Your Lordships, I'll answer that because that has been deliberately done. The destruction is deliberate. Therefore, we have to go to the secondary evidence. So I'll just come to that aspect. But first, let us examine, Your Lordships, the option of cancelling the examination. What are the consequences of cancelling the examination? And balancing all persons.
You are not even selected.
Your Lordships, I'm not.
I can understand somebody.
Other people got it.
No,
because
one minute, please. Others who have got it wrongly can be knocked out.
they can be knocked out, but then, Your Lordships, don't.
Maximum case of the petition is knock them off.
Your
But
Lordships,
don't pull down those who are not involved. But what you are asking for is step beyond that.
Your Lordships, I'm not.
And if delay in latches applies to the other side, in your case, delay in latches will completely out. What you are saying is, after you knock them off, whatever balance is left, please
Yes,
please let us fall into it.
meritorious people.
How can, no, but that.
Was when we the meritorious people. I'm just
And in
proposing.
a case where the merit list is already exhausted, the time for merit list is already,
Your Lordship-
panel list is already exhausted.
Bear with me because Your Lordships, as Your Lordships have said, this is not a simple situation. There are too many complexities involved in this. So how do we put all those complexities together and come to some solution which will take the best, all the best options can be examined, Your Lordships. So this is what I'm putting to Your Lordships, that as far as knocking of the entire selection is concerned, there are two big consequences that arise out of it, which are not permissible under Article 40. First, Your Lordships, is that as far as the people who were meritorious have a substantive legitimate expectation to be considered, because here we are not at a point of time where the case law with regard to you are on panel, you don't have a right to be appointed. But I have a right to be considered in accordance with my merit. So that right being a substantive right and substantive legitimate expectation, I can't be thrown out because SSC conducted it in a particular manner, did some ghapla here and there, Your Lordships. My valuable right, because my right to public employment is a very, very valuable right, Your Lordship, especially in the current economic circumstances. So given that fact, Your Lordships, everybody who falls into the merit list must be considered. Secondly, Your Lordships, if this whole selection goes, then what about the candidates who had appeared in the selection? Now, Your Lordships, we'll all be faced with an age bar. How do we then come with a systematic solution to that? If we are constrained by the age bar, now Your Lordships will see that there'll be new candidates who will come into the newly declared vacancies. So what does a fresh selection mean? A fresh selection means that you continue the process from stage 2, which is Rule 12(6) onwards, you continue the process, because the people who had appeared in that selection must be the only people who should be considered for fresh selections, except the ones who are tainted people. The tainted people have to go out, Your Lordships, because the tainted people.
Understood, please. That argument is a little far-fetched, but understood.
Your Lordships, it's not so far.
That's saying that only those people who had earlier appeared should be permitted to appear.
Lordships, then what, 2016, this is after 10 years. We are not talking of a situation.
Correct, but that's fine.
Ago, Your Lordships. Now, if we go for a.
That's always so when the merit list is exhausted.
Because, Your Lordships, the OMR mark sheets, as far as the OMR sheets are concerned, now CBI, Your Lordships, has very categorically said that it has done all the data mining. It has done the metadata mining as well, and has come to the conclusion that these two hard disks and Pankaj Bansal's OMR sheets match. So whatever OMR sheets are contained in that, suppose there are say 100 OMR sheets which are not contained in that. So forget those OMR sheets, there has to be some collateral damage. Your Lordships, we are willing to take that collateral damage. But all the OMR sheets which are there on the Pankaj Bansal drive should be, a merit list should be made out with that, and the process should start from there. That is my humble submission for your Lordships. And I have one more thing to say, your Lordships, because this is not a problem just arising in this matter, your Lordships. Now, this is with regard to recruitments, which are running into thousands and lakhs of people, your Lordships. This is as an officer of the court, I'm just submitting to your Lordships, because there are several.
There's one thing, counsel for the CBI, your concluded that field. Just tell us, probably what was the total number of recruitment made in the 4 posts?
Total number is 20.
Once we have
Mr.
started
Jaideep?
that, we have a chart.
Mr. Jaideep Gupta? How many were total number of appointments in each of the posts?
Around 25,000. Total appointments? The total appointments.
I will just.
25 not in all the 4 seconds.
And you have the breakup of all the posts?
Your Lordships, this we have culled out from all the various.
No, you don't do that. Let the government and the CBI tell us.
Yes, your Lordships.
You don't do that.
From
Don't
there-
do, no, will lead to further confusion.
There,
So in all about 25,000 appointments have been.
yes, sir.
How many did you advertise as, how many according to you were illegally made?
There are 2 categories in it, Milord. Our own record shows that there was what we are calling, Milord, rank jumping and out of panel, where we have not given a recommendation at all. Milord, those, Milord, appear from our own records when we revisited the record. There is a second category, Milord, where there is an OMR mismatch. There, Milord, we don't have the record. We are proceeding on the basis of the CBI's finding. So we have, Milord, given a breakup.
It's a never-ending
Your
process.
Lordships,
Will not show.
volume 6.
Another part they say 952.
I'm sorry.
Another part they say 152.
No, all this has been
This is
reconciled.
all,
There is no
Just to
difficulty in
confuse.
the figures just now. So these 2 categories, Milord, are there. Whether, Milord, there are any other categories, Milord, your Lordship will consider, Milord, based on our.
Lordship,
But, Milord, we are able to segregate each and every category.
So 2 categories only, you yourselves are saying, if there is any other category, I don't know, you may do it.
No,
That's
I know, I can, Milord, make that segregation. If you say, for instance, Milord, if your Lordship says that the last counseling is out of time, then how many people will be affected by that?
You can't know.
We can give that figure.
That figure you can give.
Similarly, Milord, we have now.
Now, there are 2 types of mismatch. One is where the marks in the Pankaj Bansal
Yes,
do not match with the marks available with you
in my son.
in your server.
Yes, correct.
And you can't even say, to be very frank,
Yeah.
whether your server marks are right or the Pankaj Bansal mark.
But I cannot.
Because you cannot say because you don't know.
Yes, yes.
From the High Court, they say we don't know.
But please,
No, but
you don't know. But if you accept, if you accept CBI report says on metadata
yes,
that Pankaj Bansal appears to be the original.
that's
But obviously the defense being taken, which will be taken by all your officers would be,
yes,
my marks are genuine
yes.
and Pankaj Bansal's marks are not genuine.
that's right.
right.
Say,
Please give me 10
no, please. Alright, Mr. Patwalia, I'll take away the tablets also. We may do like this. It's not possible.
Now you can give us his
Don't
10
you
minutes.
make us-
No, we have heard you for more than 1 hour. 1 hour each. So where we require your help, we require. We are putting questions, we want answers. Please. We have to close it. We have got 1 hour more, we have to close it by 4.
If there's an affidavit.
I would take only 5 to 7 minutes, my lord, because I have really not made any.
1 minute, please,
submissions.
Mr. Gupta first.
So,
So,
give me 5 minutes before.
okay,
Volume
5 minutes for me, my lord.
okay, fine.
Great.
I'm standing by the CBI
I was 4
investigation.
minutes, my lord.
We are accepting it and
CBI.
proceeding on that basis.
Your son.
Lordship.
And they have segregated your lordship.
Okay,
See that
according to you, as per the charge sheets filed by you, how many have been wrongly appointed?
Lordship will kindly come to our written submissions that is filed in the Supreme Court. The data and figures are there. There are,
See,
yes, Lordship.
But we have given the exact figures.
go by that.
That your lordships will find that volume 6, page 14 to 17.
It's not over yet.
Volume?
6, page 14 to 17 of the
No,
complaint.
that's in the Supreme Court or the?
It's in the Supreme Court.
Supreme
We
Court.
have filed a
Written
written
submissions in the Supreme Court.
My lord, to make things simpler, I have a printout which roughly.
No, let the CBI give.
It's already here on the screen.
No, we can't have 5.
That we can sit with CBI and will not authenticate it, will not no difficulty.
Only authorities
Cannot come up here.
not everybody.
Approximately 5,189.
5,000?
189 out of 25,844.
5,189.
Do you say that?
But that is only in case of AMR.
It's a
Lord, 240, the SSC admits, my lord, 240 paragraph, the SSC admits it is more than 10,000 and they say so far.
Milord, this
In their own affidavit, they say so far.
Milord, Mr. Ralph is
What?
wrong.
Where does this figure come
Milord,
out?
I tell your lordship, Milord, my
Still there.
learned friend is wrong because
It's your
that is a
affidavit.
statement taken from an affidavit of 2022,
So then this.
where we said that this is what we have so far.
More than 10,000.
Now, Milord, what are
Page
we
number
looking at?
14.
After that, Milord, the CBI investigation takes
Page number
place.
14.
And after the
But-
CBI investigation.
Mr. J.D. Gupta,
Yes.
the fact of the matter is,
Yes.
as per your own internal investigation, first you found about there will be figure will be close to 10, 20,
On
10,000.
their own. And
But
কথা বলছি ও।
as per your own internal investigation,
Yes.
first you found the figure will be close to 10,000.
10,000.
That's what you said in the affidavit.
No, not 10,000.
That's
That's.
I don't know where my learned friend is getting 10,000 from.
your affidavit.
we can calculate and show 10,000.
No. Your lordships will see lordships' own order.
If
Not
one-
more than
if-
10% people are tainted, your lordships. Lordships' own order dated 7/5/24.
Okay,
14.
okay, we have understood. That's one. As per, did you file any affidavit giving the sub figure of 10,000?
No.
No, you never filed any figure.
No, Milord, we have given a figure now of rank jumping plus OMR. I think it's coming to that 5,000 figure which Mr. Hegde was talking about. I'm just taking it out.
This is the chart prepared not by us on the basis of the SSC's affidavit.
That's wrong.
Milord, that is not our document. My learned friend is
Filed in Supreme Court.
It's your document filed in Supreme Court.
Lordships, the problem is SSC's,
Nobody will speak out.
very well, because they changed
Nobody
this
will
hand
say-
several times.
Yes, that's true.
5 minutes for a joint. Page number in the volume is given. 5 minutes by the clock. I missed no money.
But please wait for your turn. Nobody will speak out of turn. When we call upon you, you'll speak.
Right.
Just give it.
Why is it that I'm not finding that? The calculation.
5485.
5485. But as per Mr.
References,
There it is 10,750.
That's given by me,
that's given by.
quoting from the affidavit of the SSC filed with the division bench.
Milord, this is just creating confusion.
This is
Nothing
too
else.
far.
No confusion, SSC itself is confused.
No. SSC is not confused, Milord. At least for the time being, it is not.
One page. And we put in at the bottom
Please give it
the references.
No, these figures are there in the judgment itself.
Yes. And the reference from the CBI affidavits, we've given at the bottom in the footnote.
Sorry, 2,000.
10,000, my lords.
Yes, that will be given from different affidavits. Well, in this court, we have made an application which is an IA, in which not only is the figure given, my lord, but all the names are also given. This application, my lord, with respect.
How did you collect, how do you compute this figure?
My lord, we've given it at the bottom.
Yes.
My lord is looking at 10,000.
PD, right at the bottom, the PDF page number, volume 6, pages.
It is submission of SCC before the Supreme, before.
Please, my lord.
OMR issue means that the marks in the OMR are different from the marks available with the
SSC.
SCC.
Who then
Rank jumping is where somebody has been upgraded
position more than?
despite the marks.
And my lord, CBI gave figures which included those who are not empaneled. There is a little difference there, because my lord, CBI includes those who are not empaneled, but there may be a mismatch.
Okay, fine.
But my lord, we are concerned with only those who came into the panel, and there is a mismatch.
Okay, fine.
I have given a chart. My lord, these figures can be reconciled between us also. My lord. There's no.
My lord, the total illegal appointments are 10,750, which is 41.59% total appointment. And you have given the reference of SSC affidavit before the High Court.
Page number page number page number
Everything. My lord, that is not from SSC's affidavit.
Part of
my learned friend has been, my lord, saying these things from the beginning without reference to the record.
page number is given.
I have given the references to your affidavit also.
Fine. Anybody else? Now one by one.
Well, may I take 5 minutes, please?
Please start from that corner.
Well,
Basically, you came in the last, you get the last one.
Let me just.
Your Lordships,
Love the last
one
word.
sentence I wanted to say. I've just handed over some suggestions, Your Lordships, to augment Tej Prakash. Because after Tej Prakash, Your Lordships, this is a very widespread problem. I'm just handing it over to Your Lordships.
I'm sorry. I'm sorry. This is not your.
Sorry, let me just take my iPad.
My lord, I have some points on rejoinder.
Okay.
At whatever time, my lord, either in the
Okay,
beginning or
you finish first and then 5 minutes, we'll go by the clock.
all right, my lord, 5 minutes.
We'll stop you, anybody at 5 minutes.
My lord, 5 minutes. Number one, my lord, the finding of the High Court that SSC has not cooperated is incorrect. We have filed, my lord, 4 affidavits.
Leave that part.
All right, we have filed 4 affidavits, my lord. The only effort was to segregate, only. Well, I'll give that in a note. Number 2, my lord, the question of, my lord, there being an affidavit saying that we are not sure whether this is the last figure. These are, my lord, affidavits which are prior to the matter going before the division bench and prior to the point where the CBI has given a complete analysis of what they have found. So, my lord, that position does not hold anymore. With the CBI record, the position is complete now. Number 3, my learned friends had twice referred to, my lord, Tanvi Sarwal's case. That was an extreme case, my lord, of, my lord, people having, my lord, SIM cards sewn into their vests. That has been, my lord, distinguished by your lordships in the last judgment of Vanchika. By name, it has been distinguished, saying that this is not the approach to be followed in Vanchika. So my learned friends, my lord, have continued to refer to Tanvi without, my lord, saying that this has subsequently been referred to and distinguished. Then, my lord, the next point is that it is alleged that there are appointments, that the figures between the board and the committee. My lord, we are the commission. Mr. Hegde's client is the board. He appoints, he issues the appointment letters. We issue the recommendation, we hold the examination. Now, my lord, there is some discrepancy between his numbers and my numbers. That was what was said. So, therefore, the inference which was sought to be drawn by the High Court was that there were more appointments than recommendations. Actually, my lord, we have gone back through that record completely. It is totally reconcilable because the two parties have acted on a slightly different basis. Now, my lord, your lordship knows that when a recommendation is issued and an appointment letter is issued on that basis, the next step is that the person must report and join. If the person doesn't report and join in that post, then there will be another recommendation and another appointment letter. Now, in the first instance, the board took all the appointment letters, including those which did not fructify in actual appointment, joining. Whereas we only took, my lord, those which ultimately fructified, my lord, in occupying, my lord, the position. Now, my lord, if we go through that record and we have done this exercise, if we keep aside those who did not take their appointment, then, my lord, it is completely reconciled.
That's all. Your time is over, Mr.
So, Lord, I am for those.
May I just say one more thing, my lord? My lord, a lot is made, my lord, out of one or two things. But, my lord, the overlap between it is not followed.
Yes, Mr.
Lord, I appear for candidates who are mismatched candidates. Now, I have a basic submission to make, that is, everything is hinged on Pankaj's hard disk. Now, up to January of 2024, no other data saw the light of day. CBI realizes that only Pankaj hard disk is there, and then there is data with the board. We say the board's data is authentic. CBI must have realized they need some corroboration. For the first time in the charge sheet, which is filed in January 2024, the CBI comes out with a plea. I won't use the word story, but with a plea that there is data recovered from the hard disk of Scantech. Now, if we see the affidavit filed by CBI before the High Court, which is at page 238, they say their investigation has revealed that NASA got the job to do this. What did NASA get? NASA was to compile the data. NASA gave it to Scantech. Scantech comes to the office of the board, does the scanning there, hands it over to NASA and goes away. The question of Scantech having original record in its office cannot and does not arise. And in the charge sheet, that record is supposed to have come from a pen drive. The charge
should have been on the other side.
No, my lord, no. I am very much here. Now that record is supposed to have come from a pen drive. Today in the affidavit file, it is on a hard drive. Now all this is seriously suspect. The whole date, there is no authenticity. And therefore, my lord, we have been saying from day one, number one, that this action could not be taken until the trial is over. An investigation report submitted, there are two direct judgments of your lordship saying that
5 minutes only.
And
1.5 pages.
Second, there is no 65B certificate. I will give a 3-page written submission.
No. I was sitting in the back. I was just
I have 30 seconds left. I will give a 3-page written submission fructifying this fraud. And the data is highly, in fact, the board's record is genuine. This Pankaj Mittal's data is highly suspect. CBI is now desperately trying to get
Mittal, not Mittal. Mittal is our brother.
Pankaj Bansal. So, sorry. No. So, my lord, Pankaj Bansal, I will give a 3-page note. And
it shows our love for lordships.
So, my lord, I again reiterate, and we have been saying this from day one, unless and until the data is in a trial takes place, it is highly not proper.
Okay, that's okay.
I am for untainted, just 1 minute if your lordships will permit. I'm here.
We are
one minute, so untainted 1 minute.
I am also untainted.
Just 1 minute if your lordships.
1 minute. Anybody else arguing for tainted?
Untainted, my lords.
Long time.
Untainted, innocent, and
Okay,
clean, my lords.
5 minutes for the tainted one. Beyond what has argued earlier.
Lord, I am appearing for Group D, which is manual labor. Let's make a distinction, my lord, between the categories of people before you. We all have different grievances. So whenever they're finished, give me 5 minutes.
No, please argue now. You're for tainted.
Yes. My lord, my basic proposition is, when any action is being taken, justice demands that fault must be attributed where it is due. What is the fault attributed to me? I am a manual worker. I have applied under the rules.
of 2016, I have complied with the rules. Unless and until, my lord, I am told by way of a show cause notice issued to me that here is where you have committed a fault. The rules of natural justice have to be complied with as far as I am concerned. So, my lord, my suggestion is each and every one of us. And by the way, I don't fall in outside panel and I don't fall among waitlisted candidates. I have gone by due process of law. And therefore, I am protected by Article 311 of the Constitution of India. My lord, I have been in employment since 2019. And my lord, there is case law to indicate which I'll file in a written submission. Even if you don't invoke 311, you still have to comply with the rules of natural justice. So therefore, give me a show cause notice and I will prove to you that I have committed no wrong. Secondly, the admission of the state cannot be binding on me. Lord, the High Court has proceeded on the assumption that the state admits its own wrong. How is that admission binding on me? Where was I given an opportunity to oppose that admission? Then, my lord, thirdly, submissions have already been made on 65B. The simple submission is 65B has to be given by Data Scantech. The source who scanned it, they have not given a 65B certificate. Had they given it, matter might have been different. And last but not the least, my lord, so therefore, my lord, the crux of the matter is do not do injustice to manual labor. In our case, my lord, there's no question of my trying to misrepresent myself. I've followed the rules. The rules which my learned friend Vibha read out don't apply to me. And my lord, one last thing. My lord, one last thing. High Court says on a balance of probabilities, reading section 3 with section 58 of the Evidence Act, they overlook section 59, which says no balance of probabilities for electronic evidence. Read section 59. It says for electronic evidence, you must comply with 65B. That's all I have to say.
I'm also.
I want to.
Untainted candidates.
Untainted.
Untainted candidates. Untainted.
My lord, may I?
I want to make a brief submission that for the first time in the entire judicial process, that in this matter, after the earlier judgment of the Supreme Court, a dispassionate hearing is being given. That what started off in regard to a group D by a politically inclined judge who ordered a roving inquiry, that has now resulted in what has happened. Without a
more of the matter, we have facts now.
My lords are conscious of it, and therefore my lords are now looking at it in a serious manner.
Okay, please argue something which we.
I want to say this, even the division bench unfortunately seems to have been carried away by the media hype without giving a due opportunity to all the affected parties.
Okay.
On the tainted part, may I?
Okay, 1 minute. We start from here and come down there.
That Group D might have been several irregularities, but in regard to teachers, hardly 8 to 10%.
We know that article.
Yes. Lord, I appear for fortunately untainted people, my lord. I am not in OMR manipulation or rank jumping. I was part of the 8th phase counselling, my lord. Your lordships are interpreting the rigor of Rule 15, my lord, where the panel expires after 1 year. If your lordships were to take that into account, from leaving the first 2 phases, all phases are impacted. Now, if I am not tainted,
first 2 phases is how many were appointed?
my lord,
In first 2 phases, how many were appointed?
Phase counselling itself is after expiry of the.
After second phase of counseling.
After second phase, all are after expiry of pen.
Not all after second phase, all are.
all are beyond 1 year.
Phase counselling is after expiry of pen.
My lord, apart from that, my lord, another 2 types of illegalities are there, my lord.
My lord, can I have my 2 minutes?
Yes.
Exams are going on.
My lord, I have given those dates. So the
Where do we get the dates of the counseling?
I have it here, my lord. If your lordship would see at the top of the second page, my lord, the final publication was on 12th March 2018. The panel expired on 12th March 2019. Now, if your lordship would see the second page, the 3rd, 4th, 5th, 6th, 7th, and 8th, all beyond 12th March 2019, my lord. So if your lordships are going to set this aside, everything will have to go. including 9th, 10th, 11th, 12th. Now, 8th happened, my lord, because the High Court, if your lordship would see the second paragraph, directed that 8th phase counseling should take place. I have referred to that order, my lord. So, my lord, your lordship would have to then interpret this, keeping in mind that if they are not tainted, what is the rigor of 15 has to be.
Okay, yes.
I can only add two things to this.